When it comes to a child's welfare, things can get complicated. What happens when the person who tucks them in at night isn't the same person who manages their future? Well, today we're diving into the fascinating two-hat system in Muslim law, which actually separates the role of a guardian from that of a custodian. It's a really crucial difference, and it has some pretty profound implications.
So here's how we're going to break it all down. First, we'll get to the bottom of the difference between a guardian and a custodian. Then, we'll see who actually gets to be a guardian and what the rules are around their power. After that, we'll switch gears and talk about custody and the one single rule that can change everything. And we'll wrap it all up by looking at what happens when someone tries to act as a guardian without legal permission.
Okay, let's jump right into the main idea here. A really important thing to grasp about Muslim law is this. The person with the legal power over a child's life and property, well, that's not always the same person who's taking care of them day to day. You really have to imagine two totally separate but equally important jobs. And here's that two hats model in action. Think of the guardian as the trustee. They're handling the big picture stuff, managing property, making decisions about education, things like that. The custodian, on the other hand, is the caregiver. They're focused on the everyday life of the child, their upbringing, their health, their emotional well-being. So to put it simply, one manages the trust fund, the other provides the trust.
So who gets to wear this really powerful trustee hat? As you can imagine, it's not just a free-for-all. The law sets up a very specific pecking order. Let's take a look at how that works. The whole hierarchy makes a lot of sense when you see it laid out. It all starts with the natural guardian. If there isn't one, the law then looks to see if a testamentary guardian was named in a will. And if neither of those options are on the table, then the court steps in and appoints a guardian. Always, and I mean always, with the child's best interest as the top priority.
Okay, now here's something that really catches a lot of people by surprise. Across all schools of Muslim law, the father is considered the one and only natural guardian. The mother, despite her incredibly vital role, is not legally a natural guardian, not even if the father passes away.
In this line of succession, it continues right on after the father's death. Under Sunni law, guardianship then passes to the father's executor, the person he named to carry out his will. In Shia law, it goes to the paternal grandfather. But you'll notice, in neither case does it automatically pass to the mother. But let's be clear. This guardian role isn't about having unlimited power. Not at all. The law actually views the guardian more like a trustee, whose number one job is to protect the minor's property. And that authority comes with some very, very strict rules.
This table shows you just how tight those restrictions are. A guardian can sell movable property, things like goods or belongings, for a fair price, especially if that money is going right back into an investment for the child. But selling immovable property, like a house or a piece of land, that is way more restricted. It's only allowed in really extreme cases, like paying off the child's debts or if the property is literally falling apart. The goal always is to protect that child's inheritance.
All right, let's switch hats. We've talked a lot about the guardian, the trustee. Now it's time to turn to the custodian, the caregiver. This right to have physical custody and to care for a child is known in Muslim law as hizanat. Hizanat is really all about the day-to-day raising of the child. The law fundamentally recognizes that during a child's most tender years, nobody is better suited for that role than the mother. And it's important to remember, this right isn't for the parent's benefit, it exists entirely for the welfare of the child.
So how long does the mother have this primary right of hizanat? Well, that actually depends on the school of law. Under Hanafi law, she has custody of a son until he turns 7, and a daughter until she reaches puberty. But in Shia law, those periods are shorter, just 2 years for a son and 7 years for a daughter. After those ages, custody generally goes over to the father.
So what happens if the mother can't have custody for some reason? Well, the law has a clear succession plan for the caregiver role too. In the Hanafi school, for instance, the right first passes to the maternal grandmother, then the paternal grandmother, then to sisters, and so on. It passes primarily through female relatives to make sure the child stays in a nurturing environment. So we've gone through all these specific rules for guardians and for custodians. But what happens when following a rule to the letter doesn't actually seem to be what's best for a child? This brings us to the single most important principle in this entire discussion, the one rule to rule them all.
This right here is the golden rule. It's everything. The courts have said time and time again that their absolute main duty is to protect the child's welfare. We're talking physical, moral, and ethical well-being. This one principle is more important than any of the traditional rules, and it brings Muslim law right in line with modern legal thinking all over the world.
And believe me, this isn't just theory. It has huge real-world consequences. For example,
Traditionally, a mother who remarried someone outside the child's family would automatically lose her right to custody. But today, a court will look at the whole picture. If staying with her and her new husband is truly what's best for the child, she might just keep custody. Nothing is automatic anymore.
Lastly, let's cover a situation that can get really messy, legally speaking. What about a well-meaning aunt or uncle who just steps in to manage a child's property and life, but without any legal authority to do so?
This person has a specific legal name, a de facto guardian. De facto just means in fact or in reality. So this is someone who is in fact acting like a guardian. They're caring for the child, managing their property. But, and this is the crucial part, they were never legally appointed, not by a will and not by a court.
And on this point, the law could not be more clear. A de facto guardian might feel responsible, but they have zero legal power, especially when it comes to property. They cannot sell it, they cannot mortgage it, they cannot transfer it. Any attempt they make to do so isn't just reversible, it's completely void from the very beginning. It's as if it never happened.
And so all of this leaves us with a really fundamental question to think about. We've seen a legal system with deep, ancient roots that is constantly trying to balance itself with the modern, universal idea that a child's welfare comes first. So how do you honor that tradition while always ensuring the best possible life for the child? That's the dynamic challenge right at the heart of family law today.